Okay. Um, Hi, everyone. I'd like to welcome you to the Upper Valley Business Alliance, a legal Q&A for businesses in Vermont. This is sponsored by the Vermont Small Business Law Center, which is a program of the Vermont Law and Graduate School. And I would like to introduce Brian Bailey, who is our presenter today. Brian is a patent attorney admitted to practice before the U.S. Patent and Trademark Office, and is admitted to the bars of Vermont and Indiana. He has also been a mechanical engineer by training as well, and he has a lot of other bona fides, but I'm going to let Brian say who he is and explain it because he can do that better than I can. So, Brian, I'm going to turn this over to you.
Okay, sounds good. Thanks, Tracy. Yeah, so welcome. I am Brian Bailey. I'm with the Vermont SBLC, the Small Business Law Center at the Vermont Law and Graduate School, where we spend a lot of time doing trainings like this. And we also have students who help us along in that mission semester by semester. Um, Personally, I also run a private practice called Bailey Legal Services. I've been a practicing lawyer now for a little less than 20 years, but not much less. Most of the first, 14, 15 years of that, I spent in law firms of increasing size, sort of ending in a multinational sort of scope and scale where I did a lot of patent work. These days, and for the past few years, as a solo practitioner, I've been helping a lot of small businesses and startups, as well as some medium and somewhat more mature businesses with whatever they need. And so that's patents for sure, and other intellectual property, but also plenty of other things, leases and contracts and general advice and that kind of stuff. So that's what we're going to get into today. And, we're looking at this from the perspective of especially small businesses and folks just starting out. So from that lens, up on the screen is a bit about our agenda. So we can talk about entities, right? The classic LLC, but also the other forms, what they are, what they do, what they're for. We'll get into sort of business liability in general and insurance in particular, how they work and how they interface with entities and other things to mitigate risk for business owners. We'll get into contracts a bit. I think everybody's familiar with kind of the concept of a contract, but we'll get into some of the specifics and maybe dispel some rumors about what they are and what they're for. Of course, near and dear to my heart, intellectual property. We can go as deep on that as anybody wants to go, but for today's purposes, this will just be an overview of the various categories of IP and how they're distinct. And then the last bit, we can talk about working with lawyers. Why would you do that? And if you are going to work with a lawyer, what are some of the ways to make that relationship go well and for business owners to get what they need out of that relationship? And that's particularly salient in the context of the Small Business Law Center and Clinic at VLGS, because a big part of what we do is we'll take consults from business owners, sort of like what's going on here today, except it's one-on-one, and we'll give educational content about whatever is going on for them, whatever questions they have. But then we can refer those people, and we can also refer people who are here today or watching this in the recording to a lawyer. And we have a program where we can offer at no cost to the business owner 10 hours of lawyer time where you'll get to work with that lawyer. The lawyer does get paid through a grant that we administer from the Small Business Administration, what's called a low bono rate of pay. So it's not a normal sort of typical hourly rate, but it's a lot better than nothing. And you get those 10 hours to work with somebody. So our hope with the educational content, including what we're going to do today, is to give people sort of the basic rules of the road and expose people to some of the terms of art and just the concepts here so that when you go to work with a lawyer, if you choose to do that through our program, you already know something about what you need and you can hit the ground running and really make the most of that 10 hours because you can get a lot done working with a lawyer for 10, sort of billable hours. That's actually quite a bit. So without further ado, and I'll just also say for the participants who are here with us today, feel free to interject, interrupt, ask questions. Happy to have this be a discussion and not a lecture, but also happy to sort of just run through this, and we can always do Q&A at the end as well. Okay, so without further ado, let's jump into business entities. So this slide shows us the very basics around the most commonly considered business entities that folks will create, either unintentionally in some cases or intentionally in some cases. The first two, sole proprietorship and partnership, those are often created unintentionally. So if a person starts a business, right, starts creating widgets in their garage workshop and is selling the widgets out on the open market, internet, farmers markets, whatever, right? That's business activity. Maybe profits are being generated, hopefully. And what happens when a person does that? They just sort of get up and running, start the business, and hit the ground. That's a sole proprietorship. So we say the government requirements are low because to create a sole proprietorship, the owner doesn't have to do anything. It's just what happens by default when a person starts doing business. And there's not much that needs to happen. There's no formal requirement for registering a sole proprietorship in terms of taxes. It's all passed through, which just means that any profits made by the business become income of the individual who owns the business. Usually that's going to be declared on a particular schedule in a 1040 form that we've all seen. The schedule is Schedule C. The problem with sole proprietorships, though, is that they don't offer any limited liability protection. We're going to talk about what that means, particularly when we talk about LLCs, but also all the other forms that you see there on the chart other than the first two. A partnership is just like a sole proprietorship, except that it's multiple people. So if we've got two people who join together to form the business, that's just a partnership. And again, that's the default structure with pass-through taxation and low to no government requirements to form or preserve that form. One thing I'll note here is that when we think about a DBA, sometimes people say, "Oh, I've got a DBA." That just means doing business as. Any of these are subject to DBAs. That's a way that you can register with the Secretary of State in Vermont or other states to let them know I'm out there doing business and this is the name I'm using to do business. And that has some benefits in terms of preventing others from using the same name and just being registered at the Secretary of State. So sometimes sole proprietorships will have a DBA. But that doesn't mean that it's an intentionally formed limited liability structure like the others. So sole proprietorships and partnerships, easy to do, but the downside is liability passes straight through and attaches to the individual owners of the business. The common way to mitigate the risk that arises from that sort of pass-through liability idea is the limited liability company. So that's the classic LLC. For small businesses that we see coming through our clinic and just in general in Vermont, probably 90% of small businesses are using an LLC form as opposed to a corporation or a B Corp or these others that we'll talk about a little bit. There's a reason for that. The LLC is very easy to create. It's very easy to administer relative to the other corporate forms. It can be one member or multiple members. The process for creating an LLC is pretty simple. It involves filing what's called the Articles of Organization with the Vermont Secretary of State, which, as a practical matter, that's just an online form that can be found at the Vermont Secretary of State, where you tell the Secretary of State, this is my name, here are my owners, here's a registered agent, which can be an owner, and some other particulars, and then voila, the LLC has been created. In terms of taxation, I'll just say quickly, the default for an LLC is that it's passed through, just like a sole proprietorship. That's one of the reasons an LLC is easier than some of these others, because the IRS considers an LLC to be a disregarded entity, which just means I don't care about the LLC. You can just claim it on your Schedule C of your 1040 as income for the individual owner or owners, the same as you would have done if it's a sole proprietorship. It is possible, though, to deviate from the default in the LLC context and make it corporate taxation. Taxation rules get complicated quickly. Here, what I'll say is just an accountant is a really good friend of small businesses, because oftentimes there are going to be various ways that the business owner or owners can achieve what they're trying to do legally, but the tax situation makes one path over the other clear. And that can really find purchase, for example, in this decision over whether to be a pass-through taxation type of entity like an LLC or to elect corporate taxation. That's going to depend on the particular tax situation of the owners, on how much income is coming through the business and other things like that. So accountants are the ones who are really the pros in this regard. Accountants are hard to find in Vermont, but they're out there, they do exist. But it's better if a business goes out and tries to find an accountant sooner rather than later, because they are tough to retain. So we're going to talk a little bit more about what else goes into limited liability companies, but I'll point out one other bit of creating an LLC, which is very, very often overlooked. I would say more than 90% of the time. And that's something called an operating agreement. So we file the Articles of Organization with the Secretary of State, and the LLC is created. The operating agreement is not filed with the Secretary of State, but is a very good idea for businesses to have. What the operating agreement does is it basically lays out the groundwork for how the business will operate relative to its owners. It's sort of like a constitution for the way that the business is going to conduct itself. And sort of another kind of overlooked idea that is underneath the presence of an operating agreement in the first place is that when we create a limited liability company or a corporation or a B Corp or a nonprofit or a co-op, all those are separate legal entities which are being born essentially in the eyes of the state. So when you go to the Vermont Secretary of State's website and you go through those articles of incorporation and hit submit and pay your $155, and now you've got an LLC, what has happened is that a new legal person has been born. It's the LLC. And that's a person who can sue and be sued, can make contracts with others, can have its own bank accounts and its own assets and liabilities, just like a human person can do. So when we think about the operating agreement, what that is it's an agreement between, on the one hand, the human owner of the LLC, and on the other hand, the legal person that is the LLC. I've actually often set these up just to drive this point home to people. In the case of like a single member LLC, that operating agreement would be signed twice by the same person. It doesn't have to be done this way, but oftentimes it is done this way, where the same person is actually signing the agreement twice at the end. once they're signing as a human, right? The person. And the other signature is I'm signing, the LLC is signing this agreement through me, its owner. So this is an important distinction to keep in mind. This is something that happens when we create an LLC or these other intentional forms, is that we create this separate person. And when we think about that, that is also a big part of what gives rise to that limited liability um, function of the LLC, is that now when we think about, you know, lawyers are catastrophizers, right? We like to think about all the things that could go wrong in the future, and we're sort of always fast forwarding into this dystopian world where everybody's been sued and all the deals have gone terribly wrong, and it's everything's going badly, right? That's not the norm, but that's what lawyers think about a lot. And so when we think about liability, we're thinking, okay, so there's a counterparty to a contract, or maybe there's a tort lawsuit, right? The classic slip and fall. Somebody's out front of your establishment. You didn't shovel the walk yet. They slip and fall and sue you for their injuries. The classic thing, right? Whatever it is, you've got somebody out there who's coming after the company with a claim of damages and wants money from the company. So that person is a plaintiff, and if they win, they become a creditor, right? Where it's like, first of all, I'm saying that you owe me money, and if the judge or the jury agrees, then you do owe me money, right? And now I'm a creditor. Well, who owes that person money? Or who is that person suing? They're suing the company in general, right? So they're going to be going after the LLC. That's a distinct, separate person from the individual owner of the LLC. And so if the LLC loses the lawsuit or is found in breach of contract or whatever bad thing happens, then it's the LLC's bank accounts and assets which will satisfy that judgment. But if things are being done well, it's not the personal bank account of the owner. It's not the equity in the home that's owned by the owner. It's not the personal vehicle of the owner. Those things cannot be used to try to satisfy a judgment against that creditor plaintiff. So the LLC creates, or any of these limited liability structures, they create a separate person who stands in front of the owners and is the one who will sort of take the hit from somebody who's coming after the business as a plaintiff, or who's saying that the business owes money. So it's a protection. That's where that limited liability comes in. It's a protection of the personal assets of the owner or multiple owners. That's what a sole proprietorship or a partnership does not do. So these other structures that are listed on the chart also do that, right? They also offer that limited liability piece, even though it's not in the name. So a corporation is sort of the classic, business in the kind of popular imagination, I think, right? The C Corp in particular, that's the sort of entity which can issue shares. So corporations are good, especially C corporations are good for businesses, especially that envision scale in their future or envision the need for external funding to try to scale, right? So we think of like the tech companies of the world who have, the new killer app or product or something, and it's going to take a lot of capital to develop that. There's no way they're going to have all that just sitting in their back pocket. They create a C corporation, and then they can issue shares out to investors in exchange for capital so they can scale the thing. So C corporations are usually chosen for that reason. An S corporation is similar to a C corporation, but kind of smaller in scale. There's a limit on the number of shareholders it can have. There's a limit on the kinds of shares. There's only one class of shares in the S corp, whereas C corp, you can have these different sort of tiers of shares, which can be helpful again if you're sort of doing more complex financing and venture capital, that kind of thing. And by the way, the S corp can also be a pass-through taxation entity like the LLC, like we talked about. but its default is the opposite of the LLC. It's the corporate taxation. And when we think about a C corporation, that's always a corporate taxation situation. What does that mean, corporate taxation? It means the business has to file its own tax return. And then the individual owners of the business or shareholders or whoever gets money out of the business, they're filing personal tax returns that also they get taxed on whatever distributions, salaries, and other things they've taken from the business. So the tax situation is more complicated when we think about corporations, but sometimes there are benefits to that because corporations also get all sorts of deductions and other things. Once again, see your accountant about that stuff. So then these last three are a little more niche, and they're also a lot harder to create and administer. The benefit corporation, that's just like a regular corporation, except that in its charter, it's specifying something that it does other than maximizing profits for shareholders, which is sort of the reason for existence of a regular corporation, right? It's out there, its goal is to make money, right? And in general, shareholders expect it to put that goal above others. In the case of a benefit corporation, the corporation is out there saying, no, no, we're allowed to make money, and we're allowed to, create profits and distribute those to our shareholders. But we have another thing, a mission, which goes above the profit maximization mission, right? And usually that's going to be something in the public interest. That's a way that a corporation can sort of be on record saying, no, 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 we have another mission besides making money, and here's what it is. By the way, there's another thing called certified B Corp status. That's like a third party recognition that the benefit corporation and other corporations, doesn't have to be a benefit corporation, are sort of adhering to some kind of mission that they've articulated. Certified B Corp is different from benefit corporation, but those are related concepts. In terms of the nonprofit, a lot of people want to start nonprofits. They are not easy to get going, and they're not easy to administer. I won't get into too many details about this today, except to say that, what makes a nonprofit different from these other ones is that they're exempt from income tax, right? They don't have to pay any income tax. That's great. Also, they can receive tax deductible donations, as we all know about 501c3s and so forth. But they're also not allowed to make profits. They're not allowed to generate a profit and distribute that to shareholders in the way that a corporation can do, or any of these others. So they can pay reasonable salaries, right? So it's fine for someone to be an officer of a nonprofit organization and get paid for that work. But, the quarterly dividend thing, that's not a thing with nonprofits. And the rules around that can be quite strict because the IRS isn't requiring nonprofits to pay income tax. They have generated a whole fairly strict and strictly enforceable set of rules around how the organization manages itself. So I'll leave it there with nonprofits. And then in terms of co-ops, right, again, special rules on this, see an accountant. But co-ops, the idea behind a co-op is that you have a group of people who sort of want to be co-equal, and they want to be able to bring people into the co-op and let people out of the co-op as owners of the business. So again, co-ops are sort of a special animal. And if people are interested, by the way, we're going to give some information at the end about how you can reach us, so that if you want to get into the nitty-gritty about any of this, come to us for an educational consult, or if you're ready, you can maybe go straight to a lawyer and we'll get you referred. Okay, so liabilities and insurance particularly. So we talked about how a limited liability corporation or any of those others can limit the liability of owners. When we think about liability, what we're kind of thinking about is debts. right? So that's money owed to somebody else. Um, that can be in connection with a lease. It can be in connection with a contract. It can be because we lost a lawsuit. Any of those things can create debts. Insurance is another structure which can be used to cover liabilities, right? Particularly financial losses, things that sort of come out of the blue. So there's general liability insurance, which most businesses are eligible to get. It's just that it's sort of that classic slip and fall thing that we talked about. Um, who's on the hook if the plaintiff does end up winning their lawsuit and obtaining a judgment, right? Maybe you really should have shoveled that sidewalk, or maybe you went out and hosed it down to make it slippery, right? And then now you're really in trouble because that was intentional harm, right? So um, the general liability insurance is another structure that can sit between now, not just between the owners and the creditor or the plaintiff, but actually also between the business and the plaintiff. So when we think about these liability shields that protect the owners, the LLC is a first one. The insurance then is a second shield between the plaintiff creditor and the owners, because the insurance will do two things. One is the thing we all think about when we think about insurance. They pay the claim, right? So the plaintiff creditor wins their lawsuit and now we owe money. Instead of them coming after the LLC's assets for the money, they go to the insurance company and the insurance company pays the claim instead. The LLC's assets are protected and the LLC can continue doing its thing. Actually, insurance companies do another thing, though, which is less commonly thought about, and that is that they will help the business defend in general. So when we think about a general liability policy, the slip and fall plaintiff, the insurance company doesn't want to lose that lawsuit either. So in many insurance policies, there is a promise that they will bring their lawyers and their resources to the fight, which can be a huge benefit to small businesses who oftentimes don't have a lawyer hanging around, or if they can find one, that's a big expense to try to mount, a robust defense against this plaintiff who's coming after the business. The insurance company has a team of lawyers who do this all day long. So being able to bring that team to the benefit of the business can be a really big benefit because it can prevent the lawsuit from being lost in the first place. And so there just isn't a judgment at all, right? No money is ever owed because their lawyers are able to come and mount that vigorous defense. So general liability insurance is kind of number one for most businesses. Other kinds of insurance exist out there, professional liability, right? I have that as a lawyer. Other professions have it too, doctors, of course, but others, right? And that goes to errors and omissions or negligence in performing professional services. By the way, professional liability generally attaches to the person, regardless of whether an LLC is hanging out there or not. Professional liability is always personal liability. It doesn't, you can't really use a limited liability company to mitigate risk when we're thinking about professional liability. Also, workers' comp insurance, right? So if we have employees, that's a whole separate kind of insurance. Product liability insurance. So if we're making products that could potentially cause injury to somebody, product liability insurance is a whole separate category. What I'll say here is that insurance is insurance brokers are a friend of business owners because they understand what their products are. However, insurance brokers are also salespeople, and we can expect them to emphasize what the insurance will cover as opposed to what its exclusions are. That's where having your own lawyer, or you can try to do this yourself as well, although I've found insurance policies are relatively hard to read compared to other things. not impossible, and it does pay to just read the thing and try to understand what it says, but they're not very easy to read. Sometimes it makes sense to have a lawyer look over the policy and explain to you what the exclusions are. Because the way insurance policies are drafted is that it's, at the top, here are the things we're going to cover, and it looks broad. But then below that, here's the things we're not going to cover. Here are the exclusions, right? Homeowners insurance is a classic example. We will cover your home in the case of damage. Exclusion, flood, right? If the damage is a result of flood or even water in many cases, yeah, we don't cover that, right? We will cover you for damage, but not that damage. So that's a good example of we're going to cover you, but exclusions are where the rubber meets the road. All right, so changing gears, contracts. What is it? I think most people have a good intuitive understanding for what a contract is, right? It's an agreement between two or sometimes three or four or more parties that carries the force of law if somebody violates the terms of the agreement. So what the contract is supposed to do is, first of all, define what the obligations are, who's getting what and who's giving what. So what's the exchange? And what are we going to do if there's disputes or problems along the way, the bumps? So one of the things I like to say about contracts is that I think a lot of people think about contracts as like a tool that is used to bring somebody to court and compel their compliance. And contracts are that. They can be used that way, but they're also more than that. If they're doing their job well, they keep people out of that situation in the first place. And they do that by promoting clarity between the parties. So I like to say that contracts are literally getting the parties on the same page. It's one thing to sort of have a discussion with your counterparty trying to make an agreement and say, yeah, we're going to do it this way, and you're going to pay me this and I'm going to deliver you that. But then it's another thing to see the words on the page. Well, okay, when are you going to pay me? When are the goods due? What happens if I can't get them to you in time? What are the goods exactly anyway? What are your expectations with respect to the goods or services you're going to receive? What are my expectations in terms of the way you're going to render payment? When people read through a well-drafted contract, if things are going well, they have a discussion amongst themselves about the terms. And very often, they discover some point of tension or disagreement. And they work it out. And then they put those words on the page. And by the end, everyone understands exactly what the deal is. So when that happens well, people are reading the contract, understanding what it says, having discussions about the terms. I submit that contracts can be really effective at preventing disputes and disagreements in the first place and keeping people out of court so that it never has to be used as that tool for compelling the other party to do the thing or pay the money or whatever. So how do we make it? The basic components of a contract are, on the one hand, there is an offer, and then the other party accepts the offer, right? So I will provide you, this many widgets for that much money at this time and under these circumstances. That's the offer. Then the other side says, yeah, okay, I accept, right? That's the acceptance. And then there's consideration, which just means that you can't have a contract in which one party gives something, but the other party doesn't give anything. The sort of one-sided transfer. As a practical matter, consideration doesn't show up as an issue most of the time because courts aren't going to get involved with whether it was a good deal. They're just going to look at was something of value exchanged by both parties. That's consideration. So what kinds of things find their way in there? Pricing, timing, right? Who pays if something goes wrong? What if we need to make a change along the way? One of the things that contracts often do is say the entire deal, right? It's called an entire agreement clause. They say the entire deal is contained within this document, and anything that's not in this document, that's not the deal. What that means is all the things you've been talking about with the other party, and maybe even that you've got emails on or whatever, leading up to the signing of the contract, those things aren't in the deal unless they're in the contract. So, and similarly, if changes aren't need to be made post signing, how do we do that? Usually contracts will set out rules for that. And usually those rules say, well, we're going to create a writing and we're both going to sign it. So for small businesses, contracts usually show up as an issue. Sometimes that's for businesses that are providing services. They need a service agreement. For businesses that are providing goods, sometimes they just need agreements either with the upstream folks who are providing them with the materials they need, or the downstream customers who are receiving their finished goods, and just making sure that those relationships are being tended to and that they're explicit. So businesses can have templates which are used for this purpose. This is another good place where working with a lawyer under our grant, for example, can be really useful. Just to say, hey, I need to tighten up my contracts. I feel like, I wrote this thing and I don't know if it's doing the job that I really want to have it, have done. Please, lawyer, look at this and tell me if we need to make changes. By the way, it's usually better to have a writing than to not have it. So if there's no lawyer hanging around, having some kind of writing is generally going to be preferable to not having anything and going for the verbal thing. So what kinds of issues do we see in contracts? Negotiating it, right? Parties found a form online and looks good, sign it at the bottom. And no one read it and no one knows what it says. The negotiation didn't happen. That's the cause of common problems, because then people are bound by those terms. And that probably wasn't the actual deal. Of course, right? Another big one, not having a contract in the first place, right? Just saying, I'll do this for you, you'll do that for me, and everybody will be happy. Yes, until they aren't, right? And now when we have a dispute, what are we going to do? How are we going to get past that? That's what contracts are for. Another one is thinking there's an enforceable contract, but there isn't, right? How can that happen? The illusory promise is a big one, right? I'm going to buy 5 lawnmowers from you and 5 more if I feel like it. That's an illusory promise, right? That's not an enforceable promise because its boundaries are not clear. So nothing has actually been promised. Also, offer and acceptance, right? We talked about what that means. Sometimes things go wrong there, where, I'll offer you this many widgets for that much money. Well, that seems like too much money. How about I give you less money? At that point, there's no contract. There's a counteroffer. And so sort of navigating the complexities of that offer and acceptance can sometimes cause issues. Statute of frauds, basically what that means is that a written and signed contract is necessary for certain things. Sale of land, so land cannot be moved around on the basis of a verbal contract, period, for any price. Sale of goods over $500, so a pretty low threshold, right? If we're talking about goods that go over that $500 threshold, a writing is necessary. Verbal contract is not a contract. There is no contract. And anything that would take more than a year to complete, right? So if we're signing a 5-year, if we have a 5-year deal, I'm going to occupy your commercial space, until 2030. That's more than a year, has to have a writing. In this case, it would be a lease. So sometimes things do go wrong and somebody ends up in breach of the contract. That just means that somebody hasn't held up their end of the bargain. So breach is not illegal per se, but it can generate consequences. It can lead to civil liability. People can go to court and sue for a breach of contract to say, court, we had a deal. Here is the document that memorializes our deal, the contract. And they didn't hold up their end of the bargain. And so I want the other side either to do the thing they promised to do, or in some cases, I don't even care if they do it anymore. I just want them to pay me to make me whole for the damage that I've suffered as a result of them not performing their obligations. Sometimes breach makes sense. So, that can be a financially practical option in some cases where people will look at the deal they've made, look at the costs and consequences of a breach, which are usually specified by the contract, against the cost of continuing to perform under the contract. And sometimes people say, it's cheaper to breach. I'm going to do that, right? That's just my preference. The contract says that I owe you this much money as a result of, not performing my obligations. I'm going to pay you that because it's cheaper than trying to perform my obligations given that circumstances have changed or whatever. So it's not always like a bad thing. And I think sometimes people, have that feeling of, well, I made the promise and so I have to keep it. Well, the contract usually says the result of you deciding not to keep whatever other promise you've made. And that's an option, right? That's what contracts are for. Sometimes breaching is an option that the other party just takes. It doesn't have to be a bad thing. Okay, we've got enough time. We can go over some intellectual property. All right, IP, what is it? It's the idea behind intellectual property. Let's unpack the word for a second. It's property. It's a thing which can be bought and sold and licensed and moved around. It's a thing which can be owned by your business, for example. And so in that way, it's like any other property. It's like physical property, but it's tied to ideas. So it's about preventing someone else's unauthorized use of your work. So it can be unauthorized copying or remaking in the case of copyrights. It can be someone else trying to steal your brands and create customer confusion, right? So they start using your names or they start making products which look just like your products. That can be trademark and trade dress infringement. And there's this aspect of not just preventing other people from doing things, but actually allowing them to do things with your intellectual property, but on your terms. So that's a license agreement, right? Giving someone permission to use your intellectual property, but in exchange they have to pay you, or they have to do attribution, or they have to perform some other, they can't just have it for, and sometimes it is a license. Hey, use it. You don't have to pay me anything, but I am giving you permission because it's my permission to give, right? And I can withdraw that permission as well. So let's get into a little nitty-gritty about the kinds of intellectual property, and then we can, as we go through that, think through a little bit about how this finds purchase in kind of the day-to-day of businesses. So trademarks. Pretty much every business could benefit from trademark protection and does benefit from trademark protection in one way or another. What is a trademark? its words, names, symbols, slogans, right? So Nike is a trademark. The little swoosh is a trademark. That's a word and a symbol. Um, Just do it is a trademark. That's a slogan. So those are three different trademarks owned by the same company, which all might show up on the same goods, but each one of them separately can be its own trademark. The purpose of those things is to indicate the source of your goods or services. And by the way, trademarks are for goods. Technically, service marks that's the name we use for services. But as a practical matter, everybody just calls the whole thing trademarks. Fine. So we're thinking about indicating the source. It's intended to protect both the business, but also the consumer. Because if I go to the store with a headache and I know there's this certain stuff that always helps with the headaches, and it's called Advil, I can go look for that trademarked name, Advil, and I'm not only finding out what the product is, it's ibuprofen, I'm actually finding out something else, which is that it comes from the maker of Advil and not from someone else. So if Advil has, in my mind, the reputation for effectiveness or purity or whatever good things I associate with that trademark, then I can use it as the consumer for a shorthand because I know that I trust the maker of that stuff to give me what I need, and I don't want to go to someone else. I don't want to have someone who isn't the maker of that product making the thing that I've bought. So those indicators of quality are protecting the business because no one else can make it under their trademark names. But they also protect the consumer because they get to use that shorthand and just look for those trademarks when they're trying to find whatever goods or services they're after. So as a practical matter, trademarks aren't something that a business can just get because they want it. There are standards, and it's not a guarantee that trademark registration will be available to the business. So a strong trademark is something that's unique or fanciful with respect to the goods or services you're trying to trademark, right? So potato chip brand potato chips can't have that because it's just generic. Salty, starchy snacks with an X, yeah, much more likely. Similarly, Apple brand apples can't have it. That's a generic descriptor. That's not a trademark and can never be a trademark. Apple brand computers, though, yeah, that's totally unique. Apples have nothing to do with computers. That's a strong trademark. By the way, the TM can be used by a business who wants to put it out there that this is a brand that they are seeking to protect and that they see trademark rights in that word or slogan or whatever, TM. It's an informal thing, and businesses can just throw it up there as a way of saying, that's ours. The circle R means we think it's ours, and we've gone to the US Patent and Trademark Office and filed an application, and they've agreed with us. That's ours. So the registration is not required to have trademark rights, but it is required to enforce trademark rights in the courts. And as a practical matter, getting a registration earlier rather than later is going to make it much easier and more effective to go after people who are trying to steal your trademarks. Because a lot of times when trademark infringement is happening, the business doesn't know about it until it's been going on a while. And if they rush off and get their registration only after they've discovered it, then all the things which happened pre-discovery, the amount of damages they can seek from the infringer are going to be very, very limited, if not zero. because they didn't have the registration. So that's why registration is useful. Copyrights. So trademarks cover brands. Copyrights cover the expression of an idea. So it's a creative expression. It's not the idea itself, but rather the way that the copyright owner has expressed the idea. So systems and codes and things like that, right? We think about data. Somebody went out and figured out there's a correlation between this thing and that thing, and they looked at tons of data and developed all the data. Do they have copyright in all that data and all those things they've collected? No. But now they create a dashboard that expresses the correlation that they found. And it shows a chart or something else, or it's a dashboard that sort of conveys this fact that they've, this interesting correlation between two things that they've discovered. That thing, the dashboard, the chart, all those things, that's copyrightable. That's an expression of the idea, not the thing itself. So the thing to remember about trademarks or copyrights is that the rights attach automatically. So when pen gets put to paper and the person creates that creative expression, rights attach in that. But like trademarks, there is a registration which can be done where you go to the Copyright Office, in this case, copyright.gov, and file the registration. Why? Because it's the same dynamic as it is with trademarks. If somebody goes and copies that thing and there's a registration in place, the rights against the infringer are much stronger than if the registration has been not done. By the way, copyright registrations are pretty easy to DIY. Trademark registration is a little harder because of the limitations on getting particular trademarks. Patents are, right, they're for inventions. So devices, processes, compositions of matter, right, things like drugs. Again, not ideas, but they can get closer to covering an idea than probably any of the other forms of IP protection. And in that way, patents can be a very, very powerful tool because they can cover an invention that is truly new broadly. So the requirements for patents are pretty strict. Patents are very hard to DIY because the application process is a big undertaking, and creating a good application is sort of a mix of art and science. And there are many traps for the unwary, and it's hard to fix mistakes. But a good patent, especially for a business that has a new idea, something that has not been done before, that's the area where patents can be extremely powerful because they can broadly protect that idea in a way that competitors will not be able to get around during the life of the patent, which is 20 years from the original filing, which is usually about 17 years from the actual date of issuance of the patent if it's successful, because the process of getting the patent takes about 3 years. It's a long process. They sit in queue for a while at the patent office, then an examiner picks it up and basically tries to reject it based on whether the invention truly is new or not. So patents, not easy to get, can be very powerful. Trade secrets are a little bit like patents, except that instead of filing an application where you put it out there to the public, you keep it secret. So that's like recipe type stuff, right? Processes and methods, business information, something with value. Coca-Cola, right, is a classic trade secret. It's a recipe. Coca-Cola probably, maybe, could have gotten a patent on its new product way back when. It's probably smart that they didn't do that because they would have had 20 years from their original filing. Actually, back then it would have been 17 from grant. And then it's dedicated to the public. Whereas with trade secrets, you can maintain them as long as you keep it secret and take steps to keep it secret, you can maintain them forever, as long as you're protecting those trade secrets. And there's a whole body of law built up around how much do you have to do to protect the secret and what's reasonable in that regard. All right, so we're running out of time. I'll just say when we're talking about hiring a lawyer, um, we can help through that process. You can come to us. I'm going to put up a QR code in a second that will help you get into that process. But finding good lawyers, it's just like finding other professionals, word of mouth, uh, coming through us, trade associations, colleagues and competitors, all the same stuff that you're used to when you're looking for a doctor or a dentist or anybody else. Um, and remember that you're hiring the lawyer and you can fire the lawyer too, right? So you can ask for a free consult. You can sort of do a vibe check. Do you have good rapport? Do you feel confident in this person? Do they seem competent to you? Um, Lawyers will have to do conflict checks. They can't rep, they're for you and only for you to the exclusion of all others, which means that if they have a current client who would be adverse to you, they can't take you on because their current client gets priority. And they have that duty of confidentiality as well, of course. So, what you say to your lawyer is you can count on that being kept confidential, right? How does the cost work? That's another place where you can, you know, you can ask questions. Um, can we bill this by the job? Is it by the hour? Do you need a retainer? Do you not need a retainer? Are you willing to do something pro bono or low bono, which is sort of like what we do, where we pay them a reduced amount? Bartering, right? We live in Vermont. We do bartering. Lawyers will work for eggs sometimes, or bread, or chocolate, or who knows what. Um, and what are we working on here? Like, are you going to be my lawyer forever for all things, or do we have a particular scope and we're just going to do this project and then disengage? All right, so this form that's up on the screen is a place where you can go to get legal help. So you can scan the QR code, it takes you to our website. And then we've also got this one, which is for the free legal educational consults with us. And then you can get referred to an attorney for the free legal services. Sometimes the free educational consults are useful because they will help you understand what the moving parts are, where the questions may be, what is it that you need to have done. Usually people come to lawyers and they have a story about the problems that are facing them. And some of those things are going to be legally relevant and some aren't. And their legal relevance will lead into a particular type of project, but not another one. So the educational consult can help get you through that sort of initial thing so that when you go to a lawyer, you can say, I think I need a contract. I think I need a patent. I have a trademark issue, or whatever the case is. And that way you can just get started right away. Okay, we're a few minutes over time. We started a few over. Any questions, comments, concerns?
I think this was really great information, Brian. A question about LLCs. I've been told that when you form an LLC, um, and sometimes if you're going through a bank, say for an SBA loan or others, they do require your personal social security number with that and not necessarily the EIN of the LLC. And by providing that, you're negating the protections of an LLC. Is that true?
It may be. So if
Okay.
you're going to open a bank account, that happens with an EIN number. But I think what you're referring to is that when you go to borrow money from a bank, um, the bank knows full well that when it lends money to your LLC, the LLC will stand in the way of obtaining a judgment against the assets of the business owner.
Mhm.
The bank doesn't like that state of affairs. because the LLC may not have enough assets to cover a liability if
Got
you
it.
stop paying the note. And so the way banks do this is very, very, very common for brand new businesses or small businesses, and especially startups. They're going to say, yeah, yeah, we understand that we're lending money to the LLC, but we're also going to require you, the owner, to personally guarantee the loan.
Hmm.
And basically, they're removing that limited liability protection shield that would otherwise sit between you and the bank if you stop paying. And they're saying, no, no, no. If the LLC can't pay us, then you, the owner, you will pay us. And that's a separate instrument usually. So the LLC is saying, I, the LLC, am borrowing this money, but then I, the human, am guaranteeing that if the LLC can't pay, I'll pay. And that
Got
way
it.
the bank can come after you personally.
Got it. Do you also recommend, when it comes to trademarks, many small businesses will create a logo, and sometimes it's riffing off, say, a the logo or the brand of a larger, better known business. Um, should every business take steps to protect their trademark, or um, how does that work?
Yeah, so there are two sort of aspects to that. One is when you go to protect a trademark, you're seeking to get rights which you can use to prevent others from infringing on your brands. But you're also doing another thing. When the examiner looks at your application, if they find that someone else has rights already, which would be confusingly similar to the trademark you are using, then they will reject the application.
Mhm.
And so there's, on the one hand, the creation of a tool which could be used against infringers and which inures to the benefit of the business. But then on the other hand, there's this due diligence piece. Am I going to get into trouble with somebody else's trademark? Filing a trademark application gives you some insight into that because the examiner is going to worry about that too. And they will reject it if it looks like you are confusingly similar to somebody else. But even before you get to that point, you can ask a lawyer to do the due diligence. You can, and in fact, this is not a bad idea for businesses who are just getting started and they're thinking about branding, and branding is going to be important. Having that conversation or doing due diligence one way or the other, whether it's with a lawyer, figuring out how to do it yourself or whatever, just finding out, is someone else already using this name? If so, do they have a trademark registration on it? And by the way, separately, can I get the domain name? Because that's a big one.
Yeah,
Sometimes people get really attached to a name or a brand or whatever, only to realize they can't get the domain.
yeah,
And that can be a real problem. That's separate from trademarks, but that's important.
right, right. And and things like logos and symbols and that's all considered intellectual property as well, correct?
Yeah. Yeah, like a logo is usually going to be a trademark issue, but it can also be copyright, because the logo itself is oftentimes a little piece of artwork, basically. Right. And so there's copyright in what is the creative expression of an idea that's embodied in the logo, but then that thing can also turn out to be a brand. So it can be subject to trademark rights as a brand and copyrights as a creative expression.
Great. So really consult first is a good rule of thumb.
Yeah, as with anything, an ounce of prevention is worth a pound of cure. And so this is a big part of why we are doing what we do at the SBLC, is for small businesses just getting off on the right foot, getting some of this information and maybe having some of these things done, is kind of all they need for quite a while. There have been a lot of businesses. So, I work with the law school doing stuff like this, but I also have, as I mentioned, a private practice, and I've represented plenty of these small businesses under the grant program. A lot of times in 10 hours, they get done everything they need to have done. They get a couple contracts that they can use with their customers or whatever, maybe they figure out where they stand with regard to a trademark and with copyrights. Um, they get their name and their logo sort of set up and, get their due diligence done on that side of things. And you're off and running. You don't, a lot of businesses don't need anything else for quite a while after that sort of initial setup, right? And getting your LLC put in place and getting an operating agreement, right? Sort of that initial setup stuff oftentimes will keep businesses going in sort of a legally appropriate way for quite a few years. And they can grow the thing and really get some money coming in before they need to hire a lawyer again.
Can you say a little bit about partnership agreements? Uh, we've had some instances of members of ours who have come to us recently who, they started the business with a family member or a close friend, and everything seemed to be great at the outset, but then something happened, division of labor. There was no partnership agreement at the beginning. The business started to make some money and really gather some assets, and now you have two partners who are not getting along. So what would you recommend in that instance?
Hmm. Yeah, so that's like in the context of an LLC, that's a big piece of what the operating agreement does. It functions as a partnership agreement, it's just not called that. But the operating agreement for an LLC sets up how the partners, or in this case, they're called owners, right? The two owners or members of the LLC will relate to one another. How do people come and go? How are decisions going to be made? What happens if somebody dies or becomes incapacitated? Um, who's going to get paid? Who's bringing what into this collaboration, and how are we valuing that? Right? If somebody's going to bring sweat equity and another person's going to bring money into the business, how do we account for that? Those things can all find their way into operating agreements. And that's a perfect example of getting those things nailed down in the agreement in the early days can be worth a lot, because then it just sets expectations for how the relationship is going to be going forward. And you don't end up in a situation where two different people have, or more than two, have different ideas about how things should be. It can still happen that way, but a lot of the most common points of tension, that's specifically around ownership and how you value contributions, can be ironed out early. And there's no there's no dispute because everyone talked about it in the early days and everyone has known all along how that's going to be accounted for.
Great. Well, thank you very much for this presentation, and thank you everybody for attending. And unless there's no other questions, I think we'll wrap it up.
Well, happy to do it. Thanks, Tracy, for having us. And we look forward to hearing from the UVBA folks. Feel free to send them our way if they've got more questions.
Great. Thanks, Brian.
Perfect. Thank you.